So this is my final video on the area of psychiatric harm affecting people through somebody's negligence. They got psychiatric harm. And what we were looking at in my first two videos is that in order to claim for psychiatric harm, because you typically cannot, you have to prove yourself as either a primary victim or secondary victim. And for each, you have a different test and a different set of principles that are required. So in the case of a primary victim, all you need to show is that the defendant's negligence put the claimant in an area of danger that they could, that was reasonably foreseeable they will suffer some personal injury. Whereas when you have secondary victims, you need to prove that the psychiatric illness was reasonably foreseeable, and then you need to go through the 4 different control mechanisms. So you have to prove that you had a proximate relationship, that you were proximate to the accident itself, that you perceived the event in a way in which the courts will accept, and finally, that your mental harm must be caused by a specific shocking event. So you can see it's so much harder to claim damages on the basis of being a secondary victim. So why is this? And this is crucial to understanding. Well, Lord Stein makes it very clear why this is the case in the case of White and Chief Constable of South Yorkshire, and 1998. And he gives 4 reasons. Very simple reasons. I'm just going to say in layman's English what he says. The first reason is that psychiatric harm cases, they cost time and they cost money. They are so costly. Why are they costly? Because it's the mere fact that the courts, they need to prove that this mental harm is not just being made up for someone. It's actually true, and they have to do this by getting expert evidence, which takes time and it requires money. So if you just left it so wide open, it could have implications for the administration of justice. So that's the first point. The second point is, if people are so fixated on trying to claim damages, it stops them from focusing on getting the treatment, because they want, the illness to exist in order to prove in court that yes, it's been caused. So it's real, like, he wants people to just get on with the treatment as opposed to, trying to claim damages, although that will maybe be required because in certain cases you can't use a windfall principle that the losses should lie where they fall. It should be somebody takes up the cost. The third very simple floodgates argument, secondary victims. You're talking about anybody who's a witness to the event, which if it's an accident, you could have 1 million people anyway, or the aftermath of the event, as with the Hillsborough case, so many people were witness to it. You have a wide class and the courts literally cannot deal with it, so you need to narrow it down. You need to be specific. You need to put control mechanisms. And the last thing is to say that, sometimes the defendants, in their defense, they do have momentary lapses of concentration, and that can be translate into a negligent act. And so to burden them with, so much as it is, we put, they can claim damages for X, Y, Z, and then to burden them with the fact that their one momentary lapse of concentration could result in 500 bystanders trying to claim money off them, it would be too onerous and it would be disproportionate. So those are the 4 reasons he gives. Thank you for watching. Visit my website.